Good evening, everyone. Welcome. Thank you for joining us tonight. I am Nara Giordano, the Director of Programming, Engagement, and Development here at the LJCC. And I'm very glad to be able to host our panel of speakers tonight on the topic, what Judaism says about the death penalty and the carceral state. Before we get started, a few announcements. Safety announcements, just so we're all situationally aware. Restrooms are located in the foyer, out the door and to the left. They have locks so that they can be single user if necessary. If you need to use the phone, please step into the hallway. No parents with kids, so I will skip that tonight. I am the safety manager today, so if you have any safety or security concerns, please let me know. If we need to shelter in place due to a weather emergency, please move quickly to either one of the first floor bathrooms or the classroom just inside that hallway. And if you have to evacuate the building, please proceed quickly and quietly across the street to the playground at Hillcrest Elementary School. It is very important that if you do leave, don't get in your car and drive off, because we want to be able to account for everyone who is here. Please take a minute to locate the nearest exit. Okay, with that out of the way, for those of you who observe, we'll be holding services this Saturday beginning at 10:30 a.m. and the following Friday night, the 20th at 7 p.m. And the final Friday of the month, we're going to have a virtual candle lighting. Our Hanukkah party will take place on the 1st of the new Gregorian calendar year, and I hope that those of you who celebrate will join us. I'd also like to highlight another adult education event that we have upcoming next month. Gerontologist Dr. Susan Friedman will be joining us on the evening of January 30th as part of our Synagogue Vegan Challenge series. And she'll be speaking to us about healthy aging, lifestyle medicine, and plant-based nutrition. So tonight we are joined by Dr. Samuel Brody, Professor of Religion at KU, Rabbi Doug Albert of Kol Ami, Kelson Bonet, an attorney of the Kansas Board of Indigenous Defense, and Donna Schneewers. Did I get it? Schneewers. My husband will be disappointed in me. Chair of the Kansas Coalition Against the Death Penalty. So thank you for all being with us this evening. The panel tonight serves as the final installment in our 2024 Dying Well series. This series was meant to approach death from a plurality of perspectives: spiritual, ritualistic, communal, and practical. Tonight we will explore dying well through its inversion, which is to say dying badly, dying by violence. This panel, with its plurality of perspectives, will allow us to approach incarceration and execution in their explicitly halakhic, political, legalistic, and social dimensions. So I'm excited to bring these panelists in particular together because their various domains of expertise and experience help to create a context where we can think Jewishly and critically about contemporary punitive practices, but also because the specific perspectives that they bring enable us to think critically in turn about the tradition and what it teaches. From one vantage point at least, Judaism is defined by its self-altering tendency. Arguably, Judaism is or can be a self-critical endeavor in which new and different historical contexts not just allow for, but insist upon the revisitation and recomprehension of canonical texts. So tonight we put the tradition into conversation with our contemporary political and legal realities in the ground on Kansas. So each of our panelists will speak for about 10 to 15, oh, always with the microphone. Sam, can I borrow the one in front of you? Thank you. Each of our panelists will speak for about 10 to 15 minutes and take questions following their talk. And after the presentations, we'll open up the floor to a broader discussion. Just gonna let you guys take it over now, but I want to introduce Sam first, because Sam will be speaking, and brief bio.
I don't know if people need to know anything about me.
Okay, Sam's just gonna, he wants to go in cold.
Okay, thank you, Lara, I appreciate it. I'm gonna share my screen here because I do have a PowerPoint. And let's see, can I get it? There we go. Oh, that's interesting. It's showing the chat. Well, that's okay. So I want to start by saying that I neither disagree politically with my co-panelists, nor am I opposed ideologically to the idea that academic research should serve advocacy. Nonetheless, I have chosen to be a little bit like a little wrench in the works today, in the sense that I'm not going to focus on elements of the Jewish tradition that will most easily conduce to what we all want. I've chosen that partially because I'm a little contrary, and partially because I communicated with Rabbi Alpert beforehand and talked a little bit about what we'd be doing, and I don't want to overlap. And so since I expect that he will focus on rabbinic tradition in contrast to Tanakh, I'm going to focus on Tanakh in a little bit and then jump ahead to the present a little bit. So I want to start by just sort of framing a few big questions here. First one we might think about: how do incarceration and corporal or capital punishment appear in major texts of Jewish tradition, like the Hebrew Bible and rabbinic literature? Another one that we might think about is, did ancient Jews differ in their practices regarding these things from other ancient peoples? If so, how? And another one we might think about is, does Jewish history or history in general move in a quote unquote progressive direction in which things improve over time? Does the prison constitute an advance in that sense over public, corporal, and capital punishment? And so those of you who have studied this topic before may recognize the last question in particular as coming from the work of the French philosopher Michel Foucault, who 50 years ago, so it's an anniversary, published a book called Discipline and Punish, in which he argued some things that are more or less taken for granted now by most people who talk about this, including that punishment in general has to be considered in the context of the society that it's located in. Punishment is inherently political. It demonstrates underlying social values and concepts of authority. And punishment also reveals how a society thinks about knowledge. Why knowledge? Because every punishment implicitly assumes some concept of human nature according to which it will be effective, right? So whenever you do some kind of punishment, if the goal is deterrence, you're saying, I think the human being is such that this will be deterrent. If the goal is simply revenge, you think, I think the human being is such that this will be good vengeance, and so on. And of course, it reveals whatever that society thinks about the body. But one of the main things that Foucault talks about is the complicated nature of the idea of reform. So he focuses on Europe in the 1700s, and he talks about the disappearance of public corporal punishment, like people being whipped in the public square, and the transition to the prison, where people are held privately out of view of society, and in which they are not necessarily subject to corporal punishment, although we all know that in reality it does happen. And he argues that even though this is in public view a sort of spectacular decrease in the visible power of the state, it's actually an increase, not a decrease. Because the old state only punished the body, whereas the new state is claiming a power to reform the soul, that it can actually somehow act on your internal thoughts and feelings, and that it can move them in a good direction using incarceration. A more recent example that is brought up by some people who are arguing in this mode is lethal injection, right? Which was put forward as a more humane form of capital punishment compared to hanging or the firing squad or the electric chair. But it's been noted that the very fact of having a humane, what is considered a humane form of capital punishment, tends to increase general support for capital punishment. So like, it's progress in the sense that, well, we're not doing this horrible electric chair thing or hanging people, but it causes people to see capital punishment itself as more legitimate and therefore has multiple dimensions to it. Let's just leave it at that. So that's the perspective that I want to bring. And I want to mention one other dimension before I get into the Jewish sources I want to talk about. And that is that discourse about Jewish criminal law has often been fraught due to the execution of an itinerant Galilean preacher that you may have heard of around the year 33 CE. And this has created an environment in which it is very difficult in what are called Western countries to discuss Jewish criminal law in a neutral way. And there are many sources that are periodically pulled out of the texts of the follower of that preacher, which are used as evidence on one side or the other of that debate. For example, in the Gospel of John, Jewish authorities are reported to have said it is not lawful for us to put any man to death. But in other first century Jewish sources, such as the historian Josephus and the philosopher Philo, we have testimony to a warning inscribed at the entrance to the temple in Jerusalem against foreigners entering the premises. And this warning supposedly said that whoever is caught will have himself to blame that his death ensues. In the debates over whether first century Jews living under Roman occupation had power to execute, the passive voice is often noted in this inscription, with an implication being that perhaps what is intended here is that God will cause the death of that person rather than that the Jewish authorities would execute them themselves. But this is the level of granularity that we're often at when we're having this conversation. So I just wanted to sort of highlight that as well. So with that in mind, I want to start by answering a couple of the questions that I posed at the beginning. First, if you read the Torah carefully, you may notice that there appear to be no prisons in ancient Israel. There is a lot of capital punishment, and I think that's perhaps what Rabbi Alpert may discuss, but there is no incarceration. There does appear to be perhaps something that we would today call jail, that is distinguished from prison in the sense that it is only internment prior to the imposition of a sentence. That is, someone has done something, they're going to be sentenced, you have to hold on to them until the sentence, whether it's corporal or capital, is carried out. That confinement, today, we often refer to as jail, rather than prison, which is a place where incarceration is the punishment. That you have been sentenced, and the sentence is precisely that you're going to be held away from society in a prison. But when we see that in the Torah, it often pretty much just, when it refers to a dungeon or an actual physical location, it seems to always be non-Israelites who are using it. So an example would be the dungeon of the Pharaoh, where Joseph is thrown into, and he's there down there with the cupbearer and so on, telling him his dreams. But there isn't one in Israel, right? And scholars tend to think that this is actually true of most ancient societies. So if you read the Platonic dialogues, and I've got the famous image there of Socrates and Crito, and Socrates is explaining why he's not going to escape, right? You might think, what's he escaping from? It's prison. No, he's been sentenced to death, right? And they're just holding him until they're carrying out the sentence. It was extremely easy to just walk out of those buildings. They were not high security institutions. The point was not to keep people there. And that's why Crito is like, hey, Socrates, why don't we just skip town? He's like, no, I have a duty to be killed here. And that's the whole point of it. So it's not, in this sense, ancient Israel is not especially unique in that it has detainment, but not incarceration as punishment. So I want to highlight, and this is, by the way, all three examples. If you learn these three examples, you have learned the entirety of confinement in the Torah. You will be a master of this subject. So I offer that to you as your takeaway. These are all of them. And, our first example is the Israelites are in the wilderness. They come upon a man gathering wood on the Sabbath. And then I placed in bold here, he was placed under guard. That's the term is the same root as it's shin mem resh, the same term we use for shomer Shabbat, one keeps or observes the Sabbath. But somebody who guards somebody else is also called like a mishmor, something like that. So that's the word that's used here. He was placed under guard for it had not been specified what should be done to him. Another example of Leviticus 24, the son of the Israelite woman pronounced the name in blasphemy. He was brought to Moses and placed under guard until the decision of God should be made clear to them. And we have an example in Exodus when parties quarrel and one strikes the other with stone or fist and the victim does not die but takes to bed. If the victim then gets up and walks outdoors upon a staff, the assailant shall be acquitted. except for paying the idleness and the cure. And I bolded that because in the rabbinic interpretation, and this is the one place I'll break my rule and refer to the rabbinic interpretation, how is he going to be acquitted if they weren't holding on to him up to that? So, you know, he hit somebody, the other person collapsed, they fainted, they're unconscious, they're in bed for a couple of days, they're waiting to see if that person's going to die or are they going to get up? If they die, the person did manslaughter. If he gets up, it's a much lesser thing. But they've got to hold him until they figure out what happened. So the rabbis assume that that also refers to some sort of detainment. But notice that in none of these examples do you have a mention of a building for this purpose or like a dedicated institution. And in none of these is the incarceration used for punishment. Also, in all three cases, the punishment would be death. So the guy picking up sticks on the Sabbath, death. The woman who does the blasphemy, death. The manslaughter guy, death. Okay, so that tends to be what we're looking at if you did the thing. Okay. So this leads to a possible logical conclusion you might draw, which is why I define myself as monkey wrenching a little bit, which is that it could be argued that it's actually easier to argue for a Jewish death penalty than for a Jewish prison. And the prison is, of course, usually put forward as the humane alternative to the death penalty. You don't want to kill the criminals, so you just hold them in the prison for a long time. Jewishly, this is hard to make a case for. And I'm citing specifically here what people are not going to think of as liberal sources. Okay, I went and found the most non-liberal sources I could find so that you are not going to think that I just cherry pick this stuff, for radical purposes. Here's Rabbi Ben Zion Meir Chai Uziel, who was the Sephardi chief rabbi of Palestine, and then it became the state of Israel. And he writes, the punishment of imprisonment is distant from and opposed to the laws and punishments of the Torah of Israel. With no other choice, we must abide in accordance with the law of the land. And here he means the state of Israel inherited a system of prisons from the British, who inherited it from the Ottomans. So these prisons are already there. There's a law, there's a legal system in place that's there. Also, halakha is not the governing law of the state of Israel. So he says, with no other choice, we must abide in accordance with the law of the land, which means the punishment of imprisonment. But from here, we must learn that in the management of the prisons in Israel, there should be none of the contempt for and degradation of the soul of a person and their dignity when they sit in jail. And then I have another source from one of his students, Rabbi Chaim David Halevi, who lived from 1924 to 1998. He was the Sephardi chief rabbi of Tel Aviv Yaffa. And he writes, according to everyone, punishment is not an end in itself. Its purpose is to reform the criminal, or so that they will hear and fear. And what use is incarceration to these ends? Incarceration in various guises has existed forever, and experience teaches that incarceration does not educate the criminal. If one stole to fill his stomach for he was hungry, the very fact of imprisonment is questionable logically, and also its utility is questionable for what would this type of imprisonment fix? The economic situation of the thief would definitely not be improved as a result of this. And I apologize if I made the Sephardi rabbi have an Ashkenazi accent in my reading. I can't help it. But you can see that he is not persuaded that incarceration does anything educative, and it can't be a punishment in itself. So he's having trouble seeing the point of it at all. Right? And if you can't do incarceration, again, I think for a lot of people, the only recourse is, well, corporal punishment or the death penalty. So I want to conclude, and keeping in mind my quotation marks around the idea of progress or the idea of advancing or reforming. But a lot of people today who are Jews who are participating in restorative justice conversations in conversation and dialogue with other communities, have noted that certain passages in our great medieval jurist Moses Maimonides, who lived in the 12th century, suggest that restorative justice is also not alien to Jewish tradition. And so here's Maimonides in his section of the Mishnah Torah on the laws of repentance. Neither repentance nor the Day of Atonement atone for any, save for sins committed between man and God. For instance, one who ate forbidden food or the like. With sins between man and man, for instance, one injures his neighbor or curses his neighbor or plunders him, is not ever absolved until he makes restitution of what he owes and begs the forgiveness of his neighbor. And even if he makes restitution of monetary debt, he is obliged to appease him and implore him till he be forgiven by him. And there are a number of writers on restorative justice who argue that in some way, prison, although it is supposed to be a great punishment because you're removing a person from society, it lets the perpetrator off easy in this one sense, which is that the perpetrator does not have to face the victim, discuss directly to their face what they did and why, and actually make any effort to be forgiven. Whereas according to this, which is of course meant to apply to, and Maimonides was, by the way, the Rais al-Yahud. He was the official political leader of the Jewish community in Egypt. And so arguably he did have the power to enforce this internally, which was given to him by the Ayyubid dynasty that was in charge of Egypt at that time. So I think that raises an interesting question about other alternatives to corporal capital punishment on the one hand, and imprisonment on the other hand, although I have only made the argument that imprisonment is difficult to justify Jewishly, and I leave the capital punishment part to others. I will take any questions. Thank you.
Does anyone have questions?
There are a lot of sort of philosophical, maybe not so historical things that you talked about. Are there sort of attested episodes in which an organized Jewish community attempted to institute things like this in the historical era or in the sort of more familiar, in sort of a more familiar context to us today?
Things like what?
Well, so if the Rambam, as the Benagi community, had the power to do this, was he actually ruling that, you know, you should be doing this within the Egyptian Jewish community? And he was doing things like taxes and, you know, ruling on religious law. But, you know, statistically, somebody robbed somebody else. And then what happened? Did he write about it? Did he write about it?
That's an excellent question. You know what? I don't know that they would have thought, and I really mean I don't know, that it was the community's job to enforce repentance in that way. If you don't repent, then what happens is that this sin against the other person becomes lodged against you in the divine ledger, and then God's going to get you. So there would not necessarily have been a perceived need to have, for example, people get this perpetrator and put them down to make them do restorative justice, which is kind of how we think that maybe you should do it today, right? Like people will try to introduce it as an alternative in the court system, and then essentially you have the authority of the courts and police putting these people in a room and making them talk to each other. I don't think that that would have happened in medieval Judaism. But we also know that there are very few cases, although there are some, of the opposite occurring where Jewish communities try to gain the ability to impose capital punishment when they don't have it. And it happens a few times here and there that Christian or Muslim rulers actually turn over that ability to a Jewish community to do it. But it's rare enough that I think if I had presented on that, I probably could have also placed them on one slide for everybody.
Sorry.
I just want to point out that you said something like following repentance, and that just seems very odd.
That's what?
Odd.
Ah.
That was so interesting. All this is interesting, but the notion that there's no mention of, or there were 3 mentions of some type of incident biblically. What other kinds of discussions are there in terms of what they did? There's exile, right? Or was there other kind of like, you need to pay back? I guess that's what we were just talking about. But were there instances kind of in the Torah or the Tanakh of pay somebody back for what you stole from them, that sort of thing? Like, what were the other sorts of justice that,
Well, there was the city of refuge, which is probably the most interesting and unique one Torah-wise, which is for manslaughter perpetrators. And it's very interesting because it's entirely a concession to the mores of the time, in the sense that it was assumed that the person who was guilty of manslaughter was a legitimate target of blood vengeance from the family of the victim. But the city of refuge is established for that person to go and be safe. And in that place, it is not legitimate for the blood feud to pursue them there. And then they have to be there for a certain amount of time. But it's not a prison, it's like a whole city. So that's a kind of interesting example that I don't know comparative instances for. Yeah, but like, you know where the cities are, presumably. But like, if you are following the Torah and you respect the commandments, you're not going to go pursue your blood vengeance in that city. And then you have to, after the person gets out, it's like the statute of limitations is up, and then you still can't do it. So that's an interesting one. But exile that you mentioned in general was the worst punishment anybody could imagine. I mean, there's nothing worse than that, because you lose your entire identity. Everything about who you are is who you are in relation to your family, your clan, your tribe, all of your people. And exile takes all of that away from you and turns you into a nobody. And in the ancient world, that tended to be also one of the main sources of slaves, was people who had been banished, and then they were wandering in some strange land and they had no social connections. You were basically subject to slavery, even in societies that had rules against slavery internally. It was considered sometimes legitimate to enslave someone who was a wanderer who was disconnected. So exile was pretty bad. Yeah.
One last question for Sam.
Yeah, I feel like it's one of the first questions also about, one of the first big questions about Jewish practices relative to other ancient people. So I was just wondering a little more about that. I think specifically like the Maimonides, because you know, talk about relative to other, you know, the Muslim community, right, et cetera. So like, do we know comparatively whether there were similar things going on then in medieval Egypt, vis-a-vis Islam and stuff like that?
Yeah. Well, so you want to know more about ancient or more about medieval?
Well, Maimonides is more medieval, right?
Yeah.
Yeah, I guess either, but I just, that was like the more ancient, Rome.
Right. I mean, so Rome is where we get the term incarceration from. They had an actual building called the Carcer, the CARCER, that was like on the main square, and that's where they put people. But like in the ancient world in general, like when you're looking at the parts of the Tanakh that are about the tribal confederation, it's there. Israel is more like neighboring stateless peoples. And when you look at the part that's about, it could just be that it's sort of an oversight, but like the people who have jails are like Egypt and Assyria and Babylonia, and not the nomadic tribes, right? So maybe David and Solomon had jails, and the Tanakh doesn't really tell us about them. When they're mad at Jeremiah, they throw him in like a pit. Is it a building, or is it just like literally a hole? Hard to say. Yeah. So it could be that it's just really about the structure of the polity more than anything else. As for medieval Egyptian, they definitely had prison, but it tended to also be used as what we're calling jail. That is to say, you were sentenced to something and they held you there until it was time to serve the sentence, whether it was lashes or whether it was execution or whether it was a different kind of corporal punishment. So you weren't supposed to just languish in the prison for your entire life.
Thank you, Sam. So we have more questions for Sam. We can take them at the end. Our next speaker is Rabbi Doug Alford of Forum BBC. Rabbi Alford is the spiritual leader of Congregation Forum New Kansas City, the non-affiliated urban progressive synagogue, a place of radical inclusion. Rabbi Alford received his rabbinic ordination from the Academy of Jewish Religion in New York in 2012. He also holds a master's in Judaic Studies from the Siegel College of Jewish Studies, a Juris Doctor degree from the University of Missouri Kansas City School of Law, and a Bachelor of Arts degree in Urban Affairs from the George Washington University. Rabbi Albert is on the Missouri Coordinating Committee for the Poor People's Campaign, co-chaired by Reverends Doctors William Barber and Liz Theo Harris. Albert is an ally with Stand Up PC, the fight for low-wage workers, a faith co-chair for Missouri Jobs with Justice, and a past president of Missouri Healthcare for All. He is on the executive committee of the Missouri Conference of the NAACP and received the 2017 Harold Holiday Civil Rights Award from the NAACP branch. He is on the board of Planned Parenthood Great Plains and chairs the advocacy committee for PPG votes. Albert is also a member of Rabbis for Ceasefire and a participant in Interfaith Action for Palestine, Washington, D.C. Rabbi Albert was a featured speaker at the Kansas City Women's March in 2017. He has been the Jewish representative speaker for many years at the annual Gay Pride Interfaith Service. He was a speaker at the vigil following the full smoke coverage in Nashville. He is past president of the Rabbinical Association of Kansas City, and we are very happy to host you for a second time now, Rabbi Albert.
Thank you all. Disappointed, Sam, but I'm not a contrary voice tonight. It's my usual kind of status and place to be, but it's not tonight. Once I step outside the door, I look forward to being contrary again. As we kind of divided tasks, my place in all this is more with oral Torah than written Torah. It's a way to characterize it. I want to say one thing about written Torah is something one of my teachers said, which is, and it's true for all of our sacred texts, that you can give it benevolent or malevolent meaning. And I thought about this when you mentioned cities of refuge. I have it in my notes. I think that's probably one example where I might cherry pick to stake out my claim against the death penalty, that we actually had something, even though it was, my understanding, limited to involuntary manslaughter, it still was something that prevented vigilante justice. And I'm going to get to that piece, that public piece, in a minute. I also want to mention, in terms of oral Torah, everything outside of really a written Torah, the Torah scroll. The rabbis, the sages of the Talmud, really were assertive in their efficacy of oral Torah, and particularly Mishnah and Talmud, which is where most of my sources are coming from tonight. And so, if in your Siddurim, if you in the morning in Shacharit service, actually in the preliminary, in the Birkat Shachar, the morning blessing, there's a blessing for studying Torah, and it'll have study texts. And the study texts tend not to be written Torah; they tend to be oral Torah. They tend to be citations from Mishnah and Talmud, and then even more contemporary sources beyond that. So it's with that and the knowledge that oral Torah allows us to be flexible and allows us to, as I say, we don't have to check our brains at the door. We can take newly acquired knowledge and use it in a compassionate way to come to what we think is a better result. The other consideration, and it was kind of referred to in your remarks too, is this idea of what is known as Dina de Malchuta Dina, which is the law of the land is the law. As diaspora Jews, we like to get along with whatever the majority is and wherever we land after we've been kicked out of the last country we've been kicked out of. So we have to kind of maneuver through that space with the understanding that and this is part of where Talmud lands on whether or not Halakha imposed the death penalty, is that the Sanhedrin didn't have jurisdiction over whether or not somebody was put to death for committing a crime. The exception to the Dina de Malchuta Dina is if it violates Torah law. For us, you know, if we don't strictly adhere to things like kashrut or being shomer Shabbos, when does it rise to a level of violation of Torah law that we're going to push back on the majority rule of whatever country we're in at any point in time? So it makes for kind of a mess. One, to come to our own interpretation of Torah law, and then to see if that somehow violates the law of the land. And then within the law of the land, you've got conflicting law. I'm on the Missouri side of the state line. They seem to be vying to be leaders in how many people they can put to death. So that's not the case in every state. So if we are advocates against the death penalty, to whom do we take our attack? So there are prescribed methods of capital punishment and prescribed crimes for which it is imposed. And so, almost as an aside, one method that seems to be, and maybe you've got a different, one method that seemed to be preferred, at least in antiquity, was stoning to death. And what I liked about this, and this is really this, one crime for which it could be imposed was when a child smarted off to their parents. That they got stoned to death in the town square. My 3 boys are now in their 30s. I will admit to times when I thought, maybe not such a bad idea. A more serious part of this, though, is stoning was characterized, and I think you kind of mentioned by characterization, that it was participatory by the entire community, which made me think of lynchings, black lynchings in the South, which became public events, and how that created I don't know if it's a psyche of a position of normalization of the death penalty, or specific to racism. So some of the enumerated methods, some of the other enumerated reference methods of execution from Talmud, they're kind of bizarre, they're kind of gruesome, and so I mention them for no other reason than to sour anyone on the idea of capital punishment. One was burning in some bizarre manner, which included being buried up to your knees in mud, ostensibly with the goal of not mutilating the body of the accused criminal and keeping their souls intact as well. So if you think about halakha, one aspect of halakha is that you bury a body in as whole a position as possible. And if you remember during the Second Intifada, when there were bombings and suicide bombings, that there would be those who would go around and literally collect body parts in order to have that person be buried in as whole a position as possible. So there's some recognition of that idea in how the death penalty was carried out. Another method was slaying by the sword, and more specifically decapitated, which seemed to be something borrowed from the Romans. This was framed in Talmud as being employed much with the rationale of lex talionis, so an eye for an eye. So the methodology by which someone was murdered became the methodology by which the death penalty would be imposed. The Talmud also mentioned that this was a methodology preferred by kings, and even was attributed that this was a methodology preferred by God. Sam mentioned, and it's important that oftentimes in lieu of imposing death penalty here on earth, it was kind of left to God to dole out the punishment later on, either by, taking a life whenever that person died of whatever causes they died with, or in Taret and cutting that person off from the community. Finally, there's strangling. Again, the accused is buried up to their necks so they wouldn't fall during the execution. And 2 kerchiefs were wrapped around their neck with 2 witnesses pulling in opposite directions. The good news here is, at least in the case of strangling and burning, the research that I came up with, there's no report of either ever being carried out. So beyond that, a more pertinent question is whether any of these modes of capital punishment were ever carried out, or were these references, and most of these references in Talmud come up in Tractate Sanhedrin, were relegated to academic discussion. In other words, were the great sages discussing the death penalty in the same way that they were discussing the sacrificial toll, which hadn't been imposed it hadn't been carried out for centuries. So in the case of the rebellious son, for example, that not only did they require stoning, but after they were stoned, they were hanged. The Talmud says explicitly that it never happened and it never will. The Talmud explicitly also compares the study of the sacrificial cult to the case of the death penalty, so they extend the conversation further. And in framing the discussion as academic, the Talmud stated that the death penalty discussion was based in the need to establish halakha for the Messianic age. So not for the here and now, but what will happen in Olam Haba and the world to come. And again, the Romans had taken jurisdiction away from the Sanhedrin probably 40 years before the destruction of the Second Temple in 70 CE. Another case of being Hamalchut. All of which is to say that any discussion of the death penalty in Talmud was purely academic. Various references in Mishnah also lead to this conclusion, that any reference to a death penalty case did not provide the mode of execution, and that in two cases where the mode of execution was stated, the cases were both extrajudicial and not imposed by the Sanhedrin. That Rabbi Akiva, who was opposed to the death penalty, figured prominently in these discussions, also carried weight as to whether or not the death penalty was actually carried out. And that overall there was a tendency by the rabbis who were in a period of Mishnah and Talmud for a complete abolition of the death penalty. This is even before we get to the laws of evidence and the stringent requirements for the Sanhedrin to find a defendant guilty in a capital case. So one who adjudicates for a conviction may change their mind and argue for acquittal, but not the other way around. So if they've argued for acquittal, they can't change their mind and both decide for conviction. There are 23 judges required in a capital case. If they rendered a unanimous decision for conviction but rendered it too quickly, the accused was acquitted on the assumption that they had not adequately considered the possibility of the defendant's innocence. Possibly the greatest difficulty in getting a conviction is the requirement of 2 eyewitnesses and the requirement that the perpetrator be warned immediately prior to committing the murder that they're about to commit a capital offense. Which leads to this Mishnah in the second Makot. Rabbi Elazar ben Azariah said, a Sanhedrin that carries out an execution once in 7 years is called destructive. Rabbi Tarfon and Rabbi Akiva say once in 70 years, if they carry out an execution, the Sanhedrin is considered destructive. So a more contemporary viewpoint that I think helps us in terms of Torah interpretation and getting to a place that I think we kind of want to get to on this. Rabbi David Ellison, wrote about how we resolve seeming conflict between specific Torah laws here, and in this case here, the death penalty in the written Torah as it's prescribed, and what he refers to as jurisgenesis, the highest ideals of principles of the community, really a master narrative for the community. So we really all know kind of these broader principles, that not shedding the blood of your neighbor, which also embodies the ideal of pikuach nefesh, of the sanctity of human life. Or even when it means in the mitzvah, what does it mean in the mitzvah to not kill? Ellison described these overarching principles as a means by which perceived law builds a bridge to a better world. And you can see for a more kind of in-depth discussion of this idea, you can read Ellison's Devar Torah. He wrote an essay on Parshat Mishpatim and Torah queries, Q-U-R-I-E-S, in which he lifts up queer Jews as full and equal Jews using this idea of broader principles. So there's more than one way in which the likelihood of a death sentence is ameliorated. And circling back on Ellison, 2 ways of thinking about death penalties in Talmudic law were couched in the idea of loving your neighbor as yourself and even applying that love to the condemned criminal. A good example of this is the case of Christopher Collins, who was put to death in Missouri last week. Not only was this a miscarriage of justice in relation to the improprieties of his trial, there was evidence of emotional trauma that he suffered as a child, which was ignored, that he had come light years ahead in improving his life since 2008, that he was a source of support for other inmates as well as prison staff, and that there was a successful participation, in restorative justice, training puppies for adoption through the Puppies for Parole program. All of which to say there is really no ceiling to the sadism and cruelty of Missouri Governor Mike Parsons and Attorney General Andrew Bailey. The second tenet of halakha that makes carrying out a death sentence less likely is the requirement of, and I mentioned this earlier, to bury a body in the solar position as possible. Finally, there's, the idea of what we know is the popular phrase, tzedek, tzedek, tirdah, which is usually translated as justice, justice shall you pursue. It's not my favorite translation interpretation. The one I like better is to pursue absolute justice, which is to say in the context of where it appears in Torah, what it really means is to strive for police and judicial tribunals that act in a just way. That we establish a system of justice that does not discriminate or engage in racial profiling. For example, in my state of Missouri, the NAACP actually has a travel warning for the crime of driving while black in Missouri that disproportionately convicts and then sentences black defendants to the death penalty or ignores clear evidence that would exonerate a convicted defendant and allows them to be executed, notwithstanding the petition from the district attorney to overturn the conviction. So even if we get past every other good reason to abolish the death penalty, the injustice of sending even one innocent life to death is more than enough justification for me to rid ourselves of capital punishment. And with that,
Thank you, Rabbi. Any questions?
You know, the two chats I put in, somebody did a clap, in response to something that I said. Makes me wonder what's the position of
the one time that I'm aware of is they apply. And I'm not, you know, I think it's possible for treason. But other than Eichmann, I'm not sure where, maybe you know where if it's been carried out at any other time.
Yeah, the problem is Israel is not de jure, it's de facto, right? So I think the capital punishment is not actually used at all as the end result of a judicial procedure. But it happens that in Israeli prisons, people die.
And what about, here in Houston, countries to this day, there's still like punishment of talking about somebody's home. I'm not sure what it is. Yeah, like,
Sort of its own Lex Kelly on an eye for an eye.
yeah, has that been, have you seen that?
I mean, I think
No, I was gonna say, you know, it quickly became the value of whatever, you know, part of the body was injured. So it wasn't taken literally. It's, you can blame us for personal injury law commercial, because that's the substitute.
Rabbi Alfred, in your sort of professional activism and I guess advocacy, have you found that arguments from sort of the rabbinic perspective are received with the same grace that arguments from like a pastoral perspective, not from a Jewish position?
I guess the short answer is yes, at least you could argue that I kind of live in somewhat of an echo chamber of progressive issues, but
yeah, Missouri is a particularly capital state. You aren't sort of going this alone, you're working with others.
yeah, I mean, there's an organization, Missourians, to abolish the death penalty, and there's a lot of clergy that shows up in that space. It doesn't seem that either their status is Christian clergy or my status as rabbi is persuasive to the executive branch in Missouri at this point.
Any other questions for Rabbi Alfred? Yeah, our third speaker is Kelson Gilmore. Kelson is a trial lawyer in the death penalty defense unit of the Kansas Board of Vigilance Defense Services. He also teaches jury selection at the University of Kansas School of Law and trains attorneys locally and nationally on jury issues, motions writing, and sentencing advocacy. Previously, he served as a trial-level capital defender for the Virginia Indigent Defense Commission, and he began his career in public defense with the Denver Trial Office of the Colorado State Public Defender. He has participated in legislative campaigns to repeal the death penalty in 3 states and has dedicated his personal and professional life to ending state-sanctioned killing.
Thank you, Laura, and it is so awesome to be here and to talk about this issue with this community as an outsider. And kind of my personal interest and personal awareness about the intersection of the death penalty and Judaism, there was always kind of a latent understanding, but I think it really crystallized in, I believe it was 2019, with the Tree of Life shooting in Pittsburgh. And that sort of 4-year legal process that ended up with a man named Robert Bowers being found responsible for that and being sentenced to death. And so, I guess tonight, I think the 2 things that I can provide are a legal overview of the death penalty and specifically where we are in Kansas with that. And then talking from my professional perspective about the people I represent, doing, again, as an outsider, what little I can to further this conversation that I think is broadly about our sense of mercy and what your faith talks about and teaches them. So beginning with that first, I guess, thing that I can hopefully offer is a little bit of national perspective, zooming in to the state. And I think there was just a comment from somebody asking the question about Missouri being this very active capital jurisdiction. And so what we see in the United States is, I think most of us here know, the United States as a whole does not really have the death penalty in any form. What we have to this day is 27 states in the federal government that have it in some form. And even within those 28 different jurisdictions, we have kind of a very broad spread of how it actually works in practice, this de facto idea. And kind of on one extreme end of the spectrum, we have what we call the 5 active death penalty states. And that's Missouri, Florida, Texas, Oklahoma, and Alabama. And we've begun to have some aspirants to join them, but hopefully that does not happen. And then on the other end, we have these de facto abolition states where the death penalty remains on the books, but there are, even if there's a small number of new death sentences coming forward, there's no legal movement to actual executions. And that would include states like Pennsylvania, California, Oregon, and a couple of others as well. And so Kansas sits somewhere in between on those. And Kansas is unique because it has had the death penalty, well, another way I should say it, it is the newest state to the death penalty in this country. We talk about the modern era of the death penalty, and we're talking about this era from 1976 forward. That was the year that the United States Supreme Court kind of lifted a 4-year moratorium on that for the nation as a whole. It had found that there were these widely disparate practices on how it was applied and who it was applied to. And then in 1976, it begins to bless kind of new state schemes on how to impose that. And so Kansas did not put the death penalty back on its books until 1994. This is the 30th anniversary of the state's modern era of the death penalty. And it's just for everybody's edification here, what has happened in that modern era is there have been 15 death sentences in those 30 years. 9 men currently sit on the state's death row. There have been several whose sentences were overturned. There have been several who have died of natural causes on death row. There has not been a new death sentence in this country since 2016. I'm sorry, in this state since 2016. I wish I'm not. And I'm happy to report that there's not another capital trial scheduled until at least 2026. And so the reality is that we are going to go about a decade in this state without a new death sentence being handed down by a Kansas jury.
And that kind of length of time is actually one of the hallmarks of states that are ready to abolish the death penalty kind of politically. We have not had an execution in Kansas in the modern era at all. There's not been one since 1965. And for the gentlemen who have been sentenced to death, they are still kind of not even, I would say, maybe half to 2/3 through the whole appeal process to the point where there would actually be some kind of execution warrant. And as we sit here in this state today, there are only 2 trial level cases. These are the cases that actually have a Kansas prosecutor that has announced his or her intent to seek the death penalty. So we are kind of at an all-time kind of waning of that in our state, which I think is notable. So the other kind of factual information I've conveyed here is just how this works and looks in practice. And this is true for most states, but in Kansas, when somebody is accused of a death penalty eligible crime and they are brought to trial, the way that this works is there is a first part of the trial that most of us, I think, are familiar with fictional accounts or what we see on TV or what you may have been summoned to jury. And that is a trial that's going to determine that person's guilt or innocence. The jury has to be unanimous to find them guilty beyond a doubt. And so only if a person in Kansas is convicted of capital murder, there's a special law that we have in anything with the death penalty. And capital murder is not just an intentional and premeditated killing, thought about it, meant to do it, did it. But it also has to involve some special circumstances, such as killing multiple with intention and premeditation, killing a police officer, killing somebody in the course of some enumerated sex crimes. Those are all kind of these threshold crimes to make somebody initially eligible. And so if a jury finds somebody guilty in that first part, the trial with the same jury moves on to a second sentence phase. And the first thing the jury has to figure out in that second part is another question that actually makes somebody eligible for the death penalty. And Kansas lists out 8 additional criteria. These are called aggravating circumstances. And so some examples would be, was the crime especially heinous, atrocious, cruel? Was it committed to avoid arrest or prosecution? Were there other people who were put in danger of death or great bodily harm in the commission of the crime? And so again, the jury has to unanimously find beyond a reasonable doubt that one of those factual scenarios exists. And at that moment, finally, a person in Kansas is eligible for death. And then what happens is in this sentencing phase of the trial, the defenders are then putting forward mitigation. And mitigation is this idea of kind of anything that could speak to mercy, anything that could speak to a sentence less than death. And that is going to be different for every person who's on that jury and in this room. And what it looks like in practice is that the jurors go from this collective body of 12 to they go to these individual moral decisions. And at this point, somebody on trial, they're entitled to 12 individual moral judgments about whether death is the appropriate penalty. And if even one juror of those 12 finds that the legal technical weighing is the aggravation outweighs the mitigation beyond a reasonable doubt, is the simple way to put it. And so if even one juror finds otherwise, then the sentence is life. The jury has to be unanimous beyond a reasonable doubt to sentence someone to die. And what the jury is doing here, I guess just transitioning to some of the problems with the death penalty and this idea of mercy, is they're weighing these really awful crimes with the nature of who a person is and how they came to that point. And a saying that always stuck with me about this, and that a lot of law professors have talked about, is it's like we're trying to ask jurors whether a stone is heavier than a string is long. We are asking them to compare these truly awful, heinous crimes. I mean, every murder is heinous by itself. But then compare it to these people who have had horrific lives that so few of us can really, truly understand. And so, it's this very fundamentally difficult, and I'd argue flawed premise for how we can even get to this idea that a person isn't worthy of living. And so, there are lots of legal problems with the death penalty, but what I want to focus on with respect to the Jewish community, and really all communities of faith, is jury service and death penalty. And to serve on a jury in a death penalty case, a person cannot always impose the death penalty for a conviction for capital murder. This eye for an eye, that's the classic example. And the inverse, though, is true, that a person who will never consider or impose the death penalty for capital murder also cannot serve. And so right away, I think a lot of people in this room understand the really severe effect that can have on this cross-section of people that are going to serve on these juries and make these judgments. What we empirically know from social science research about this process of death qualification of these juries is that Black and brown people are disproportionately excluded because their communities obviously feel the sting of capital punishment currently. We know that women are disproportionately excluded because they are far more likely to be skeptical or reject capital punishment. And then what we also see in broad swaths are the exclusion of people of faith in this category. And we even saw an extreme example of this in California recently, where kind of on a post-conviction process, it was found out decades later that a prosecutor's office in the Oakland area was specifically, targeting Jewish individuals in the jury pool on death penalty cases with this assumption that, they're too soft, they're too liberal, they will never impose the death penalty. And you see the same things with the Catholic community and others who are, by virtue of, their faith, their personal morals, if they live those and are true about them, are excluding themselves from the jury. And it's a very kind of stealth but real problem that not a lot of people are aware of. And, in my opinion, and a lot of the pretrial litigation that we do, it violates a number of state and federal laws to me. This idea that you're excluded from an important aspect of public life because of the faith that you live and practice. So I think the last thing that I can maybe contribute here is, again, just this idea of mercy, because that's something that we talk to juries about over and over and over from the minute they walk in for jury selection, often to what is maybe 5 or 6 months later, which is them actually listening to us arguing about life or death in their decision. And, in that Galilean preacher you referenced that some people might have heard of, in the New Testament of the Bible, I think it's Romans, there's this Christian idea that mercy is never earned, but mercy is given by the merciful. And so, we talk about that obviously in a secular way to juries, but I think it's an interesting just mental jumping off point for this community as well. And it's something I'm eager to learn about as somebody who doesn't have the Jewish conception of mercy. And, to that point, I think what it requires us to do is it requires us to think about that sense of mercy for who actually the death penalty affects. And we have this saying in the American system where the death penalty is for the worst of it. And what I always tell people is, I have seen plenty of crimes that are the worst of the worst, but I have never seen a person that is the worst of the worst. And we are talking about people who have severe intellectual and cognitive disabilities, clients that I've had who are unable to get their mom's $20 bill and go to the store and bring home the items they were supposed to, or bring home the correct chain.
clients who are so severely mentally ill, they're delusional to the point of psychosis and not understanding reality. Mr. Bowers with the Tree of Life shooting in Pittsburgh had severe schizophrenia. There are clients who have just these horrific childhoods and adulthoods riddled with trauma and abuse that so few of us, I think, again, can understand. Siblings who have had to, carry weapons to protect themselves from rape by parents and step-parents, domestic violence every night, broken light bulbs and windows in the home every morning, and a client whose mother, his first concrete memory was his mother being murdered by his father in front of him. And, clients who have grown up in these areas where there are thousands of times the safe amounts of lead and other heavy metals as set by the EPA. These are the places these children are, playing in, swimming in, and I think a lot of us can guess at the brain impacts of that over time. And so, that's kind of the discussion point, and I'm curious to hear from the rabbi and Dr. Brody just about what the sense of mercy is, and if there's a spiritual component to how somebody is given that. And that is, really what death sentencing is at its heart, is there a reason for mercy, and especially for the people that the death penalty falls on. So with that, I'm happy to take questions or comments.
Thank you, Kelson. Any questions or comments?
Sort of, it's, I guess, maybe a comment, we'll see if there's a question.
Sure.
The issue about jurors being excluded on account of their religious commitments, you're suggesting that's like a problem, right? If I understood that correctly.
Yes.
But it's weird how that also just puts interesting pressure on the notion of, separation of faith and state, right? And on some level, the practical impossibility of this for particularly people of faith, for whom the most minute aspects of their life to the largest aspects of life might be guided by those particular impulses or commitments. So sort of more of a general comment on that, but how this, I never really thought about the particular case of a juror. I mean, the most extreme case you're mentioning who is given along with 11 others this ridiculous amount of authority. I mean, I say ridiculous, obviously all of their life experiences are going to play some kind of role in the kinds of criteria and the evaluations that they make going into this. So yeah, like I said, I'm not sure if there's a question coming out of that, but more just I mean, yeah, what a bizarre process of the whole thing, and what sort of all the contradictions that are involved in our democracy in some sense are brought to bear, in that particular example.
Well, to reply to that comment, no, that really hits it on the head well, and I think that it's an absurdity that we're asking these people to become these individual moral decisions, but we're sort of, to serve on this, we're imposing this very, I don't want to say it's arbitrary, but it's very artificial, maybe that's the right word, law between these. And when courts have upheld this process we call death qualification, they've said, well, it's not the jurors' religious faith as the reason they're being excluded, it's the action that they won't be able to follow the court's instructions. And that's this, to me, that's just so dumb. And it's so refusing to acknowledge the reality that, faith for people of all backgrounds may be how they have those deep moral convictions that would, make them the perfect people to apply whatever their sense is.
I guess building on others' comment in your response to it, as somebody who is involved with the jury selection process, are you able to sort of give any advice to people who are subject to being called to serve on
Sure, yeah, no, so as the officer of the courts, as they call us, you have to be honest. And I acknowledge how awful and difficult that is. I say though that we want everybody to be honest because I need honesty from people who do not come from where you do. You know, if somebody tells me they're going to kill my client, I have to believe, right? And so everybody has to be honest in the process. It does lead to this moral conundrum, for especially now for everybody sitting in this room. By being honest, am I furthering the likelihood of the process of a death sentence by excluding myself? And that I have no moral answer. You know, I tell you what the legal answer is. Now I will turn to none other than Sister Helen Crajon, who many of you may know from the Dead Man Walking movement. She's been a death penalty activist her whole life. And somebody asked this question of her at a talk I was at about 20 years ago. And, you know, so if a Catholic nun told me it was okay, I'm going to say it's okay. What Sister Helen said is, you know, we're all open-minded people. And we are all wondering and second guessing and trying to learn new things and incorporate new data and perspectives into our lives. And so what, you know, the law doesn't bar somebody from sitting on a death penalty jury who has qualms about the death penalty. That's not what the law says. The law says that you can't sit if you won't give meaningful consideration for the sentence. And so the sister's advice was, you know, truly take that opportunity to listen to the case and, you know, be true to yourself and say, is this the kind of case that would make me reevaluate my beliefs about the death? Is this so bad that I believe that a sentence of death could be warranted after I listened to all the evidence? And if you can truthfully answer that question, yes. If you can truthfully say, I can listen to this and I can give meaningful consideration, then you can stay. And then as Sister Helen Crajon said, then just say no. So, but in all seriousness, I think that's the moral quandary and the internal gymnastics we have to do with this. Can you say honestly that you can be so open-minded as to, you know, listen and find out, is this the case that makes me change my mind?
Well, they say, first of all, that we Jews are very good at legal fictions. Maybe we can take something from that. I'm going to just say something personal here. My wife, in her previous career, did pro bono legal work, which meant that in a couple of instances long ago, she worked on death penalty appeals in the state of Florida. One of her clients was someone who was convicted of felony murder. In other words, like he drove the getaway car or something, but he wasn't like the guy that actually pulled the trigger. But nevertheless, he received the sentence. And she was involved in trying to get that reduced to a life sentence. Her observation is, who among us wants to be remembered for the worst day of our lives? You know, because nobody's perfect, and everybody does something that they're not proud of. And her client was not proud of what he did. Had no problem with the notion that he should never have his freedom again. I'm sorry, this is very hard.
It's okay.
when our baby died, we got a letter from prison, which is one of the most moving and compassionate communications that we received from anyone in that awful time. This man's humanity was intact. He was a model prisoner. He got his GED, he got college credit, he was a voracious reader, he was a mentor to the other prisoners. I guess that's just all I'm going to say about mercy and about this topic. Thank you.
None of us are who we are on our worst day, but that's what the death penalty is saying that somebody's continued existence is defined forever by that worst moment. And so thank you so much for sharing that. And I think that, you know, I wish more people had that perspective and understanding about the good and the meaning people's lives can still have. Thank you.
We have a question online from Leslie Mark. Can the panel talk through the concept of guilt nefesh? Pronunciation, Rabbi Anson, is that correct? Duty to save a person's life if they can, weighing on an observant Jew's service on a death penalty.
Well, and I mentioned it in my initial presentation. It is kind of an overarching concept that you can violate Shabbat to save a life, and to me, I don't know. It just in and of itself, it seems obvious in relation to imposing death penalty. I'm grappling with the idea of how mercy or compassion or ethic Hebrew is exhibited. And I guess I have a sense that in acknowledging the imperfection, not just of the person sentenced to death based on their worst day of their life, but of our imperfection. And that's a lot of what I talked about, is the persistent imperfection of the judicial system, notwithstanding even those who are of good heart and try to administer justice in a compassionate way. You know, I think bad things can happen, wrong decisions can be made, and I think it's, you know, in terms of Pikuach Nefesh, to save a life, the sanctity of human life. I think in this general context, to acknowledge how imperfect the system is, and that there is no way to make up for that imperfection if you were putting somebody to death. And that's how I would kind of maneuver through that morass.
Well, I know we have one more presenter, so maybe we can
Wait. All right.
Our final speaker of the evening is Donna Cheweiss, a native Kansan. A native Kansan, Donna is a graduate of Marymount College of Kansas with a Bachelor of Science in Nursing and a minor in Religious Studies. In 1988, she moved to Topeka in order to engage in two works close to her heart: critical care nursing and death penalty activism. In a 40-year critical care nursing career, she saw firsthand the trauma suffered by victims of violence and their families. As a death penalty activist, Donna has served for many years on the Kansas Coalition Against the Death Penalty Board. Currently, she is chair. In her work with KCADP, Donna has been involved in legislative repeal efforts in public education, especially. One of the formative events of her life was getting to know Wiley Willie Otey, who was executed in Nebraska on September 2nd, 1994. The experience of the last weeks of his life gave her a first-hand understanding of how the death penalty's impact goes way beyond the person who was executed. Tanya?
Thank you so much for the opportunity to be here. In my years of working on the issue of the death penalty, I've looked at it not only as a death penalty question, but the nursing lens comes in at times too, as how I look at things. But what's become abundantly clear is that when there is the tragedy of a homicide, that then has the death penalty applied to it, there is ongoing harm in a much larger way than there is when the death penalty is not involved. If you think of a spiral, and in the center of the spiral, you have an X. That represents the point of the violence, where one or more persons inflict ultimately fatal violence on one or more. And when we think of who is harmed, our minds obviously go to the victims and then to their families, because those families have been thrust into a space where there's no going back. Their loved one is gone. They can't do anything about it. It brings up all sorts of emotions and quandaries. They didn't ask for this change in life. Somebody they love is gone. And so there's a whole journey that they are on, even outside of the legal context. When a murder is determined to be death penalty eligible, as Kelson talked about, it meets one of those 7 specific criteria relating to premeditated cases. When the prosecution makes that decision, we're going to go for death in this case. That has ramifications for the victim family. It has ramifications for correctional staff, for the public at large. It has ramifications potentially for the jurors. And even people as seemingly not as intricately involved as journalists. I want to talk about 2 sets of multi-person homicides that happened in Wichita 24 years ago, because they illustrate how the death penalty makes a difference in the impact of the case. December 7th of 2000, there were 4 young African-American adults who were murdered. LaShonda Wheaton, Dessa Ford, Jermaine Levy, and Quincy Williams. There were 2 African-American men arrested and charged in the case, Cornelius Oliver and Earl Bell. So it's African-American on African-American, and there was a domestic violence element in this case. When that case went to trial, one of the defendants was acquitted, Mr. Bell, and Cornelius Oliver, though charged capital, ended up with 2 premeditated first-degree convictions and 2 felony first-degree convictions. And his sentence was 120 years in prison. Starting December 11th-ish, there was a series of criminal actions that took place in Wichita. So just a few days after this quadruple homicide. The first one that is pertinent to our discussion was the death of Ann Valenta, a woman, middle-aged, a cellist, and she was murdered at her residence. And then on the night of December 14th, 15th, was the one that often comes to mind when people in Kansas talk about the death penalty. And that was the deaths of Heather Muller, Aaron Sanders, Jason Beppert, and Brad Hackett, where the defendants were Jonathan and Reginald Carr. A case of horrible brutality, and there was 1 woman who survived. So 4 dead from that criminal escapade, 1 woman's life put through a lot of trauma, but she survived. When that case went to trial, the Carr brothers were getting the death penalty. Now, when somebody is sentenced to prison, like Cornelius Oliver was in the first case that I talked about, He's remanded to the Department of Corrections. He begins his prison sentence. There are some appeals that are available, but they aren't that many. And there is a sense of resolution to the case where the family can begin to try to deal with the new reality of their lives. When someone is sentenced to death, however, they are sent to prison for punishment. And their incarceration is just like this temporary thing, similar to what you were talking about, Dr. Simon, where they are being held pending the imposition of the sentence. And in the meantime, these cases, because according to the US Supreme Court, death is different, there's a lot more legal appeals that go on. And in that process, the ongoing reality of these cases comes before multiple different judges. It comes before multiple different attorneys, both state and defense as well. The reality is that there's different ramifications for the families between that case that goes to resolution fairly quickly and the ones where there's all this time, what I think of as the long wait. In February of this year, there was a hearing before House Judiciary Committee on the hypoxia bill, where the current district attorney for Sedgwick County said something that was quite enlightening. He talked about these two sets of homicides that happened in December of 2000, and how at the time, he thought the unlucky families were the families whose loved ones' deaths did not get a death sentence. And he now realizes that he was wrong. He said, quote, he has a difference of opinion. They lucked out. Those families did because they did not get a death sentence. That case is done and has been done for decades, close quote. And he went on to talk about how now, as he's dealing with families who have lost a loved one to a homicide, and it's a question about whether or not to go for the death penalty, he tells them a death sentence, what a death sentence means is that you will buy yourself 30 years worth of this process. And he tells them, I'm not going to be here to see the end of this. Some of you won't be here to see the end of this. Because there are people whose family members have died waiting for the imposition of the sentence. And so there's a very real impact on victim families. But there's another set of persons who also are impacted about this. And it's people who we don't often think about, and that's the correctional staff. This was something that was in the minds already of people in the field of corrections in the 1990s. Secretary Simmons, the Secretary of Corrections in 1998, talked about how in Kansas, we're going to incarcerate these individuals at El Dorado to do the executions of Lansing. And that was because they were realizing that if the persons involved in the execution knew the inmate, there was greater trauma to the correctional staff. Missouri does the same thing. They house them in one place, they execute them elsewhere. Some states do things like, if you're on the strap down team, you can only do X number of executions before you have to take a break. But there are some folks who don't have the luxury of being allowed to have a break. I'm thinking of people here who are the primary executioner, the people who are the warden. And last week, the Death Penalty Information Center on the 5th posted an extended statement about the death penalty and correctional staff people. They talked about a warden, an executioner in Mississippi, who said his job was, quote, being in a car wreck that goes on forever. They talked about Ron McAndrew, someone who has a military background, who ended up as a warden in Florida at a time when Florida used the electric chair. Ron McAndrew began to drink a bottle of scotch a day after an execution where a man's head caught fire. He then talked about how he would be, quote, haunted by the men he was asked to execute, close quote, and would like wake up in the middle of the night and see them at the foot of his bed. I've heard other stories of people who have been involved in executions, and they'll be out in the general public. Just imagine yourself walking down Mass Street, and in the people coming toward you, you see the faces of those you've executed. Now, prison staff and leaders have known about this problem for 30 years, and they've done things to try to address it, but it is still a current problem. Because last year in Oklahoma, Kelson mentioned was one of the states where there's a large number of executions. Correctional staff actually wrote to the Attorney General asking to have the space between execution dates lengthened out because of the psychological toll it was taking on them. And in their letter, they talked about how it wasn't just the people who were actually involved in the execution, but it was also the trauma for the other correctional staff who saw how hard it was on the people involved in the execution. And in their letter, they literally said, quote, post-traumatic stress disorder, substance abuse, and even suicide increase among correction staff following proximity to an execution, even among those who did not participate directly. Sister Helen Prejean tells the story of Major Felton, who was involved with 5 executions, and his job was very remote. He wasn't on the strap down team, wasn't in the execution chamber. He went to the inmate's cell to pick up their belongings so that they could then be disposed of according to the inmate's directions previously. He said, I can't sleep. I can't eat. No, it's legal in my gut, but I know we're killing people. And this was a man who knew the horrible things that these people had done, but he still could recognize the humanity. As I was preparing for tonight, I knew I needed to talk about my experience in Nebraska. I had gotten to know Willie when he requested that Amnesty International look at his case. And so at the time I was clergy because I was a Catholic sister, and I was able to have contact visits with him at different times than just when everybody had gathered in the visiting room on a given day of the week. So I got to know Willie a little bit more. As I drove up the day before the execution was to take place, was, 1994. There weren't as many things to listen to on the radio and on channel surfing. And I listened to this call-in show where they're taking calls from listeners about the death penalty. There was one caller, and I had forgotten about these comments until I was going through some materials today. They literally suggested that instead of an electric chair, we just ought to have a couch so we could do multiple people at once. There was another person who referred to the Nazi ovens as something to be considered. Outside the prison that night, there were estimated to be 1,000 people there. It was a big deal. Nebraska hadn't executed since 1959. It was an African-American defendant. The woman who was murdered, Jane McManus, was white. There were people there with sparklers, people there banging on skillets. There were racially derogatory signs, but the sign that to this day sometimes causes me to just kind of pause and stop and visually remember the scene was the sign that said Nebraska State Pen, first annual barbecue, because it was electric chair execution. That sign, the folks who made it and who carried it had no concept of the dignity and humanity of the man who was being executed. And to go back to what Kelson said and to what Barry talked about, how there is more to every person than the worst choice they've ever made. Cantor Reeser was there that night. He was at the South Street Temple in at that time. And I remember him being there in the group protesting the execution. And he opened the temple that night for people who wanted to come and have a place. I couldn't go. I just was too not in a space. I had to be by myself and kind of think about things. About a week later, he described the scene outside the prison as a carnival celebration of the death of a man. He talked about the bloodlust. And he talked about how it was an example of the sorts of beliefs and behaviors that fuel much of the individual acts of crime. The death penalty affects the victim's family. It affects the defendant's family, who often are shunned and ostracized, even to the point of having to change their names. It can impact jurors. There are jurors in cases who voted for death, who now realize, oh my goodness, there was so much more to this case than they told us. And they don't want it to be carried out. And if you're a juror caught in that situation in Missouri, good luck, because it ain't much. And you're gonna have to live with the reality that you made a decision to vote for death. And the governor didn't fix it when there was a problem with it. Participation in being a news person at an execution can have impact on journalists, and it can take a toll, a definite toll on attorneys who are working for their clients' lives. So I believe there are no winners when it comes to the death penalty or homicide case. And that is all the more true when you look at the fact that as states, not only Kansas, but other states as well, we spend huge sums of money in seeking that death. And then you look at what is available to help victim families heal or to help communities heal. In Kansas, the Crime Victim Compensation Fund maxes out at $25,000 for victims of violent crime. If there was somebody murdered tonight who was the breadwinner for a family, the loss of wages that is paid out is $800. There's some money available for funeral expenses. There is a big, in my mind, it's like not going to cover any amount at all of grief therapy. It's a very small number. There's some counseling dollars available, but it caps out at $25,000. So it is imperative that we look at this question about the death penalty, because when the death sentence is carried out, it is carried out in the name of all of us, because it is a crime against the state. And so I want to thank you for being here tonight to learn more about this issue and to grapple with it. If you want to know more about, I'm going to call it the non-Jewish aspects of this, because that's not my bailiwick, not my area of expertise, I invite you to check out our website. I invite you to check out our literature report. I also encourage you to contact your legislators. Your legislators need to hear from you so they understand how you look at this. And that is true even for people living in Lawrence, Kansas. You have legislators who've been good, but they need reinforcement. They need to know that there are people with it. And contacting legislators is important, even if one's legislator is a Democrat, and it's true no matter whether it's rural or urban. We also want to invite you to think about ways that you can begin the conversation with others. Whether it's you belong to a club and you're looking for a speaker, or maybe you're more into movies, documentaries. Just Mercy is a wonderful book that could be a book club. The video could be watched. The movie is great. And there is a new one out right now on Paramount Plus that is called I Am Ready Wood. It's a 36-minute documentary out of Texas. And it's about the case of a man who was ultimately executed, but it looks at the death penalty and how that plays when the person is asking for forgiveness. And then finally, I want to invite you to consider joining the coalition. You can do that on our website. You can do it on the clipboard over there. In closing, my years of work on this issue have taught me very much how the death penalty just keeps that spiral going. That initial X just loops in more and more and more folks. And we could do so much better for the victims of crime, for their families, and for the communities who have been harmed.
Thank you, Donna. Are there any questions or comments for Donna? Judy?
I would like to thank you, Don, for your very eloquent and wonderful statements. I actually have a question I want to bring up the notion of mercy, because I think it's not really understood how important it is in Judaism. And so I would like the Jews on the panel to address that.
Well, I was trying to think of what is the word. And Rabbi Alpert said a couple, and there's also chesed, which is sometimes translated as mercy, although it's usually translated as loving kindness. Yeah. But it's the word that the rabbis most commonly pair with justice as a contrast pair. And there's a famous midrash where God tries to create the world a whole bunch of times and fails. And one of the times God tries to make a world that's based on only chesed, and it doesn't work. And then God tries to make a world that's based on only justice, and it doesn't work. And in order to have the world, there has to be both of them. And I thought of that because of this idea that, like, inherently by saying that it's not justice, it's saying that it's not deserved. Justice is giving everybody what they deserve. Loving kindness is whether they deserve it or not. So if you were to measure it out based on whether they deserved it, then it would be justice. So I think that is an important example.
Yeah, and that's, in liturgy, we talk about these two aspects of God, and you see it a bit in Kriyat Shema, between the Baruch Hu and the Shema itself. You have this all-powerful God, and that's the God who we tend to think we'd like to think when we pray petition for something, that God's capable of delivering the goods. But then you have the second aspect, which is this parental God who's compassionate, who's involved in our lives, who anthropopathically sheds tears when we shed tears, so on and so forth. And so I'm swinging back to that justice piece, and what I was talking about is we cannot effectively, perfectly administer justice. And if we can't do that, then we have to compensate for it with so the mercy piece to me comes with an acknowledgement of our own imperfection. And I was thinking with your comments, what struck me again, it goes back to the Peacock method question that came from Leslie. I know it. That there is a moral PTSD when people are asked to do something to which they have been raised in terms of their own, say, religious morality, that is something we don't do. Killing is something that is morally wrong, we don't do it. And yet, it comes up for people deployed for military service and war zones, so on and so forth. But also, with your comments, it had moral PTSD clearly happens for correction officers who were involved somehow in the process of administering the execution, even tangentially. So I think for whom we show mercy or compassion is a whole range of people who are impacted by the death penalty.
And maybe for Michael,
Yeah,
you wanna say it?
like which the
Yeah.
justice rolls down like.
Do justice for mercy.
Say and walk humbly with your God. Yeah, I mean, as much as I kind of advocated for Ellison's version of broad, principles of justice, I'm also wary that we say them and they tend to lose their meaning because we keep just repeating them without kind of getting into the weeds a little bit on what that really means and how we go about pursuing justice. Although the walk humbly with your God, our imperfection is that acknowledgement of the humble.
I just want to say that was engraved on the outside of my grandmother's shoe.
Oh, no wonder it's stuck with you.
To the last question, I think, in the, Kabbalistic chart, that, both of those elements are there and on opposite sides, as I recall, but not positive of that. So I want to ask anyone or all of you about something that Sam sort of alluded to in his presentation, which is the evolution of methodologies over time. And this lethal injection thing has always bothered me because it's so medical and so sanitary, and it's like, we're not really killing them, we're just putting them to sleep. And I'm wondering if any of you would like to comment on how the change in methodologies has had any impacts on public opinion or how things play out in reality.
So yes, there are people who believe that it is, quote, just putting people to sleep and they're just peacefully going away. When we had our hearing in February, Dr. Joel Zeiler, right, from Georgia, talked about the autopsies of people who have been put to death by lethal injection. Those autopsies show that there's far more going on than is apparent to the people who are watching from the witness rooms. The people who have been put to death by lethal injection, there's a high number of them that are found to have marked pulmonary edema. Pulmonary edema being when your lungs fill with fluid. And so what makes this all the more horrific to me as an ICU nurse is that in many of these states, not all of them, but in many of these states, when they do these executions, they may also use a paralytic. So you have someone whose lungs are filling with fluid, and the natural anatomic physiologic response is to try to take and increase your respiratory effort to try to keep your body's needs met. And they can't do that because they're chemically blocked from their respiratory drive. So there's more and more things out there about what lethal injection is. Even for the people who think that it's, quote, going well, states are running into increasing problems with access to drugs because drug companies are like, oh no, don't be using our stuff to kill people. And I just saw something this weekend. Tennessee had bought drugs in the past few years for like that would have been for 2 executions, and their costs were well over $150,000. Because what's happening is many of these states have to go to the compound market to try to get the drugs. And so the whole access to lethal injection is becoming a huge issue. There's many other problems as well, having to do with IV access and those sorts of things. So that's why states are talking about hypoxia, like happened here in Kansas. Some states are again revisiting firing squad and other methods. But I'm going to just stop by saying it isn't as peaceful, and even I think it was, well, I won't say, I don't remember, it was George Schwittero who I was reading, talked about having been physically biting, and it was clear it was not as peaceful as what took people in the witness room.
It's about 7 p.m., so I'd like to ask our panelists if they have any final remarks or questions for one another. Any final questions?
Just one thing I would say, just to appreciate all that I've learned from the other panels.
Yeah, me too.
Yeah.
Just very quickly, have there been instances, more of a legal question, of like jurors like perjuring themselves, like getting caught lying, saying that they're like, they would be open to the death penalty? Hypothetically.
So, yeah, that's really tricky. There's, you know, if somebody's convicted of a crime, certainly if they're also sentenced to death, there's this exhaustive multi-decade investigation that a good defense attorney should be doing into every juror, because if there's some kind of juror misconduct, you need to uncover that. And there are so many instances that are very well documented of jurors lying about their personal background or experiences in a negative way that puts them on a jury where they very obviously can't. Some common examples are lying about being the victim of a kind of crime that's the person has been accused of. And I'm not aware of somebody who has been kind of caught in this idea of lying about their willingness to impose the death penalty or not. But it's always a concern. You know, our sort of maxim in capital defense lawyering, you know, is if somebody tells you they're going to kill your client, you got to believe. And we, you know, at the end of the day, are there just to try and make a safe, open, non-judgmental environment for people to be themselves, no matter what that is. If somebody's going to tell us eye for an eye, as paradoxical it is, we want to hear that then, because we know that if that gets unaddressed and goes back to the jury room, it becomes a death vote. We are never going to convince them in a 20-minute interaction that they should change a closely held view about something as serious as the death penalty. So we embrace that honesty, we thank them, we kind of pat them on the head a little bit, and then we try to pick them out of the game.
I may have gotten those first. So I meant like, so let's say I might be like, it was like Hitler or something, you know, like, so could I say that to it, you know, if I was trying to.
I have actually seen people say those exact words and escape a state's challenge for cause to kick them out. The defense lawyer has basically backed like, what about Hitler? And they said, yeah, sure, I could listen to that trial, and they're good, right, you can stop. So it's that's what I said earlier. It's this willingness to see, is this the kind of trial that'll change my mind? You know, we have all maybe wasted our lives. We're all wrong about this issue. Are you willing to sit through the trial and find out, is this the case that convinces me otherwise? That's the legal predicate to being able to serve on a death penalty.
Azaria, is this a question?
Well, I want to offer a comment about a different halakhic interpretation that I find I can absolutely answer. Yes, I will give meaningful consideration, and the chances of me ever possibly imposing the death penalty are so infinitesimally small, it's hard to even imagine. For me, that comes from the morning prayer, the Hareini Mikabel Elai Mitzvat Ve'ahavta L'Recha Kamocha. Here I accept on myself the obligation of fulfilling my Creator's mitzvah in the Torah, love your neighbor as yourself. I will give meaningful consideration to the death penalty by loving the victims of whatever the crime is as I would want to be loved in that moment, giving full consideration to their anger, their grief, their pain, because that needs to be heard. But at the same time, I am also obligated to love the person who is on trial as I would love myself. And as somebody who would never want to be killed under color of law or color of mob, that really does close out that possibility. So I want since I'm disabled and can't function in the mornings and so will never be called to serve on a jury, I want folks here to have that tool. We have a mitzvah both to give meaningful consideration and to not impose the death penalty.
Sorry. Well, thank you so much, our panelists, for being here tonight.
You all.
Everyone, for you're invited to enjoy more cheese and wine at the admin office. Oh, you guys leaving already?
Yeah. Big one.